I really wanted to start with this basic point of what makes contracts special, because those of you who know us through our contract review service will know that when it comes to contracts, with those reviews, we're diving straight into the detail of fitness for purpose clauses, indemnity clauses, really complicated stuff. But we don't often have the opportunity to go back and look at the fundamental importance of contracts. Why are we putting so much emphasis on these documents in the first place? You deal with a whole bunch of communications, some written, some verbal, on a project. Why are contracts so much more important than all of those? Contracts are given special legal status by the law. They are legally binding on the parties to the contract. And what that means is once you have made a contract with somebody, you can't just walk away from it, almost no matter what they do, unless the contract specifically allows you a right or an avenue to walk away or to terminate. If you breach your contract, you can be sued and have to pay compensation to the other party to the contract. And damages for breach of contract are assessed at a very high level by the courts. You generally get better damages for breach of contract than for almost any other legal right you might sue for. So when you do see claims against consultants, among all the allegations, there is usually an allegation of breach of contract. Practically nothing else that you deal with on a project is more powerful than what is in your consultancy agreement in terms of defining your rights and your client's rights. When I say practically, I just do have to note that legislation passed by Parliament can override contracts, and there's often examples where legislation does expressly override contracts. For example, security of payment legislation and rights under the competition and consumer legislation. So to put that another way, there is a whole bunch of interactions that you have on a project. You have meetings and decisions that are reached arising out of those meetings. You have discussions with other parties. You have negotiations about the contract, about all the minute decisions made on a project. You have exchanges of emails. You have industry conventions, the way things are usually done. But in terms of defining your legal rights and your legal obligations, none of that is as powerful as what is in your consultancy agreement. The contract really, even though it's only one document, outweighs all of those other dealings. A lot of other dealings that you have on a project draw their power and effectiveness from the contract itself. For example, you know that you have to comply with the brief or the principal's project requirements or whatever title it's given on your project. That isn't because there's a piece of legislation somewhere that requires consultants to comply with briefs. It's because somewhere in your consultancy agreement is a clause that says you have to comply with the principal's brief. Likewise with scopes of services, they draw their effectiveness from being annexed to your consultancy agreement or from a clause in your consultancy agreement that refers to them and requires you to comply. When the client gives you directions, your consultancy agreement often defines what kind of directions can they give you. How do they give those directions? Are they verbal or in writing? Your right to claim fees, and particularly your right to vary those fees, all set out in the contract. Your right to claim extensions of time, again, a creature of contract. So it's important to look at what EOT rights you have in any consultancy agreement you've been given. Your right to terminate your services. You do have certain common law rights of termination that sit over and above your contract, but those are quite vague and not rights you would be wanting to rely on. So it's important to have a look at your consultancy agreement and find out what termination rights you have. And as an illustration of all of the last 3 points, if you're a consultant in the construction industry, you're probably quite used to working on the basis that your client can sack you at the end of every stage if they want to. They usually don't, but they can. That isn't because the contract isn't binding on them. They don't have some sort of God-given right to walk away. The reason they're able to terminate you at each stage is usually because the contract specifically says so. If you look at the termination clause in your consultancy agreement, it normally says the client is entitled to terminate your services at will, which means even if you haven't done anything wrong. So all of those powers come from the consultancy agreement, from the contract itself. The last part of this section, I just wanted to touch on some commonly used terminology. Many of you will know some of these words, maybe not all of them. So this word contract, it means the things I've talked about in the previous slides. It's a legally binding agreement between 2 or more parties. In order to be legally binding, contracts, according to the law, have to have consideration. Consideration means something of value given from each party to the other. So in a consultancy agreement, that's really clear. The consideration you give is your services, and the consideration that the client gives is payment for your services. So that's this word contract. A contract should be in writing, but if you don't have anything in writing, what you have is a verbal or implied contract. This word agreement, it's often used as a synonym for contract, and the law doesn't really make much differentiation between those two terms. Whether you sign a consultancy agreement or a consultancy contract doesn't necessarily make a difference to your liability. Deed, however, this word does have special legal meaning. A deed is a particular subspecies of contract. To sign a deed, the signature has to be in a particular form. A deed, unlike ordinary contracts, can be binding without consideration, which is why you see it often used in the context of novation. In novation, it can be hard to trace the consideration flowing from each party to the others, so it's done in deed form to avoid that argument. The other thing about deeds is they have extended limitation periods, which means you and the other party can sue each other for a much longer period of time if your contract is in deed form.